Hello, my name is Evan Hartsock, and I'm here to talk to you today about an important Supreme Court case that further protected our First Amendment rights, specifically the freedom of the press, in the case of the Miami Herald versus Tornillo. In the fall of 1972, Pat Tornillo was the executive director of the Classroom Teachers Association and a candidate for the Florida House of Representatives in Dade County, Florida. During Tornillo's campaign, the Miami Herald, the local paper, published a series of 2 editorials criticizing he and his candidacy. Now, at the time, the state of Florida had a law in place that created a right of reply statute. This statute granted that a political candidate had the right to equal space in a newspaper to publish his or her response to criticisms and attacks on their record, free of charge. This statute also made it a first-degree misdemeanor for a newspaper to fail to comply with these requirements. The Miami Herald decided not to give Tornillo the space they were required to give by law on the grounds that they felt that they should have editorial control over their own publication and that the right of reply was infringing on the First Amendment rights by forcing them to publish something that they didn't want to. So, as they failed to meet the requirements, Tornillo brought a suit against the Herald in the Florida Circuit Court of Dade County, seeking declamatory and injunctive relief and actual punitive damages in excess of $5,000. The Circuit Court held that the right of reply statute was unconstitutional, saying that it infringed on the freedom of the press under the First and 14th Amendments to the Constitution. The court concluded that dictating what a newspaper must print was no different from dictating what it must not print. The circuit judge viewed the statute's vagueness as serving to restrict and stifle protected expression. Tornillo requested an appeal to the case, and it went to the Florida State Supreme Court on a direct appeal. The Florida Supreme Court reversed the lower court's decision, holding that the right to reply statute did not in fact violate constitutional rights. The court claimed that it furthered the broad societal interest in the free flow of information to the public. The case eventually made its way to the U.S. Supreme Court for review. The court, in a unanimous decision, reversed the Supreme Court of Florida's decision and held that Florida's right to reply statute did in fact violate the freedom of press found in the First Amendment. In an opinion written by Chief Justice Warren E. Berger, the court recognized the risk proposed to the true marketplace of ideas by media consolidation and barriers to entry in the newspaper industry. However, even if in that context, press responsibility is not mandated by the Constitution and cannot be legislated. The statute was an intrusion into the function of editors and imposed a penalty on the basis of the content. Chief Justice Berger relied on the New York Times versus Sullivan decision in that the right to reply statute limits the variety of public debate and was therefore unconstitutional. This case affected the communications field greatly as it dealt with the government trying to force a newspaper to publish material. It was very significant as it restricted the government's ability to do so and enforced the First Amendment rights granted to us in the Constitution. It was very important because the media should be able to criticize both government officials and candidates without penalty, so long as it's not libelous. And in this case, the courts found that it was not.